Welcome, everybody. This is Bernie Wolfsdorf. I am the managing partner of the Wolfsdorf Rosenthal Immigration Law Firm. We're going to do an update today. My partner, Joe Barnett. Say hi, Joe.
Hello, everyone. Thanks for joining.
So two quick announcements, folks. Number one is on the right side of your screen. You can click on and ask a question. So type in your question, start typing now. I'll probably be answering them anyway, but please feel free. I'll try and get through all the questions that we have. Please keep them short so we can answer them quickly. And number two, the standard sort of advisory. This does not constitute legal advice. The opinions are those of Joe Barnett, and we are not officially providing legal advice. For legal advice, of course, feel free to reach out, 1-800-VISA-LAW. That's our main telephone number, 1-800-VISA-LAW, or email us, probably email Joe. It's going to be more efficient, jbarnett, B-A-R-N-E-T-T, jbarnett@wolfsdorf.com. So be thrilled to handle any follow-up questions you folks may have. So just watching the time here and getting started. Our topics, of course, today, let's see if this PowerPoint thing, do we have the PowerPoint up?
Yeah.
Ah, it's not working.
No, it must.
Huh?
Aha. Love it when technology works. There we go.
Sorry, guys, I am technologically challenged. It's got something to do with my age, but anyway, what can I do? I've got a tech guy here. So what we're going to talk about is the impact of the proposed regulations. On, as you all know, June 27, the regulations cleared OMB with some changes. I'm going to tell you what I believe is in those regs. And I'm going to fill you in on what we expect to happen with those regs and what the overall picture is. We do have some cutting edge information that we'll be able to share. I wouldn't go out and publish it or republish it because A, we don't know if it's completely reliable, but I have a sense that this information is the best available. Number two, the program sunsets on September 30th, as everybody knows. It's been renewed, I think, over 15 times. My expectation is it will be renewed. To my knowledge, there is no bill filed. There's certainly a skinny bill circulating, which would extend it. We're not going to go into that in any depth. We're going to do a quick retrogression update. As everybody knows, China, India, and Vietnam, what to expect. And then lastly, we'll talk about redeployment, which is Joe's topic because it's certainly one of the most cutting edge and confusing issues to have to deal with today. Number two, I am going to add an update on 1044, HR 1044 and Senate Bill 386. Why? Just because there's a whole lot of buzz going on about it. What is House Bill 1044? This is the removal of the per country limitation of 7% for employment. It also, of course, impacts family as well, but I'm not going to talk about that today. My personal view is with all the buzz, yeah, it cleared the House by 386. Let me have a look at my notes. It's overwhelmingly passed the House, but I wouldn't get too excited about it. 365 to 60 is the exact score, something like the women's soccer team victory that, come on, we're all proud of what they did, proving that America is great and doesn't need to be made great again. Our women's soccer team just proved that. Pardon my little enthusiasm there, but I think that's a nice little sideline. Back to the topic of the proposed regs, something everybody wants to look at. Thanks, Joe. So what's the big deal? You've all seen this slide shot. This is the June 27 notice that was published by the Executive Office of the President while he was at the G20 conference and while he was out of town. And this is what we call the Obama regulation because it was introduced in January 2017 while President Obama was still in office, at least for another 3 days. And the important point to note where it says concluded action consistent with change. What does that mean? That is line 3 or 4 on the left-hand side, consistent with change. So what it means is the reg cleared OMB, some changes were made. The changes, I understand, relate primarily to the minimum investment amount for a TEA, which was initially set at 1.35, and the actual change was to reduce it down to either 930 or 940. So everything I tell you comes from my little magic crystal ball. I have this little black magic crystal ball, and I shake it, and and it gives me information. So it's not that reliable. And if it turns out that I'm wrong, please don't sue me. But this is the latest information, and it's probably pretty good.
If you don't mind. So a lot of times when you go through the regulatory process in creating a new rule, there are public comments that get put in. And so for this one, there were about 850 public comments that were submitted during the 3 months after this was published in January of 2017. And so what DHS is supposed to do under the rulemaking process is to analyze those comments, to see what alternatives are out there to what was originally proposed, and to modify the rule as necessary to meet the goals of what Congress intended. And so that's what this consistent with change means. Many, many, many regulations have the same thing. It's the initial regulation that's been proposed gets changed throughout the regulatory process. Those changes will eventually be published in the Federal Register, which is a public document that anybody can go. You can online and go check out. You can also register to get notified when that actually does get published in the Federal Register as well.
Joe is such a good lawyer for all of you who are interested in the law. Most of us, yes, I am a lawyer too, we want to know what actually happened. So bottom line is that the change related, my understanding, to the bottom minimum investment amount reduced from a ridiculous 1.35 million down to a semi-ridiculous 930 or 940. But bear in mind, what this NPRM rule does is it also attacks the TEA. And the TEA that we know will die with this. And my guess is that probably, wild guess, 80% of current TEA projects will not qualify, maybe 90% under the new rules. So that kicks us into the top end of the proposed regs in terms of the minimum investment amount being 1.8 million. My understanding is 1.8 million is the number for non-TEA, and 930 or 940 is the number for the very few TEAs that will in fact qualify under the new rules.
So there's a delta of around 900,000 between TEA and non-TEA. And interestingly, it also remains the same multiplier, right? It's double the amount like it is right now.
It is indeed.
Or around double.
But I don't want to talk about it is, because what we are saying is purely speculative, and we will know probably very soon, within a week or two. It is possible that these regs, now it's entirely possible as well that President Trump will kill these regs. For those of you who have time, and I know there's none who do, Joe and I published a letter, which was an open letter to President Trump to please kill these regulations, Obama regulations, because they will kill the program. We will see these regs coming out relatively soon as a final reg, but here's the magic information. Everybody is saying, when will they be effective? Yes, it is true. They could be effective within 30 days or even immediately. However, the talk on the street, which is what I'm sharing with you today, is that the regs will only be effective 120 days from the publication date. Now, why is that 120 days from the publication date? And why are these regs going to be so awful? And the answer is that the program sunsets on September 30th, and what DHS hopes is that Congress will in fact jump in and fix the mess. So the key element here is that we are about to see some horrible regulations coming out. They were horrible as proposed. They are going to be fairly horrible, in my opinion. I mean, there's some good stuff in there. There's a little bit of protection if you have an approved 526 and the project fails, that you can maintain your priority date. There's a few nice things in there. There's some fraud protection things which are good. But on the two big items, which is the minimum investment amount and the TEA, expect it to be absolutely terrible and restrictive, and it is effectively, my understanding, going to be used as a tool to force Congress to act before September 30th. Now, you know, getting Congress to act is not easy. We've seen our president struggle with this, the Dems struggle. Getting Congress, the word dysfunctional is used on a daily basis. So our only savior is the possibility of moving forward on legislation. And I think everybody is going to be united in terms of getting some viable program through statutorily. So we're going to have this awful reg. There's going to be complete chaos, in my opinion, over the next few months until such time as the regs come into power or come into force. And at that point, scratch that. It's going to be fairly chaotic until such time as we have a statutory amendment which will, in fact, hopefully correct the program. For your information, there is what's being called a skinny bill circulating. We're not going to get too much into the skinny bill. Joe, I think you have a summary in your notes. I just want to reference it. Where did it go? Anyway, there.
I don't know where it went.
It got eaten by the mice. We have a mice problem here. So in any event, the skinny bill that is circulating is a reasonable bill. And the industry is in fact united. IAUSA, I don't know if AILA signed on, but most entities signed on. We seem to have unity, roundtable, everybody's in on this, that the chances are we will have some decent legislation. So running through this again, as the fiscal year 2019 draws to a close, USCIS recently published I-526 filings. It appears that in the last quarter we are down to the 2010 level of filings. The enormous surge that we saw starting in 2011, probably peaking in 2015 and 16, has all evaporated. The government's response, Joe, you just showed me a projection where the government is predicting that they're going to have 16,000 petitions filed a year in the proposed regs, and then 25,000 petitions filed a few years from now. Not even worth showing anybody, but that proposal is actually in the NPR regs. That is ridiculous. The problem that we now have, which is, the questions are starting to pour in. So as 2019 draws to a close, we are seeing visa number filings drop down pathetically. My biggest fear is those projects that do not have alternative sources of funding may not proceed. I think it's going to be dry season for regional centers. I don't know how they're going to keep operational when, in fact, there's no revenue. So let's hope Congress does jump in, save the day for us all. And
just to answer a couple of these questions that we have on the PowerPoint, well, one is, do we know when the when the rule will be published in the Federal Register? The answer is no, we don't know. That is an unknown.
But we are guessing. We are guessing that it's going to come out within the next week or two.
And generally under the federal rulemaking process, there's about a 30-day lead time. Bernie is suggesting, well, that might be extended out to 120 days.
I'm doing more than suggesting. It was in my little magic black ball. The 8 ball said 120 days, and that is new information which I think we can share. And again, the rationale for 120 days is that takes us beyond September 30th and gives Congress the opportunity to fix the mess. So these regs are being used more as a threat, but let's put it this way, a very scary threat.
I agree. Retroactivity, will this impact pending cases in general? When you're doing a rule, it's only prospective. There will likely not be any retroactive application. So you file your application prior to it becoming effective. You would potentially be grandfathered in under the current set of rules, the 500K minimum investment amount, the TEA definition as it currently stands. One question that we see or have been reading about are the skeleton filings, or folks who don't have the full 500K available now. Maybe they have 200K or 250K. Is it a good idea to file and be in the process of investing, which is allowed under the regulations and the statute? And what would happen in the event that you invest only a portion of the minimum investment amount and there's changes? Well,
so I have a conservative view of this one. It's been done. I've heard there have been approvals, but there's also been denials. My view is that unless the $500,000 has been clearly identified, the source is clearly identified, and you're merely in the process of transferring that money, that might have a chance of getting approved. Remember this whole cutting buck analysis that you must 100% qualify as of the time of filing is the overall thinking. And the bottom line is that, in my view, you really need to get that $500,000 in, and that's not $495,000. It's $500,000 exactly. In order to be safe, if you put in a lesser amount, in my view, you have to clearly identify that all the additional money has in fact been sourced. The rule for my clients is I really want you to transfer all of this, otherwise you can expect a possible denial. I don't want to get sidetracked. Have we answered all these questions? Gosh, very good questions, actually. Let's just go back up. Whoa.
A lot of good ones.
What is the approximate maximum age a child of an EB-5 Indian investor could possibly still immigrate as a dependent, considering the long wait line for 526 and 829? So this is the million-dollar question that everybody wants to know right now. So Joe, let's get a collection of where we are. In May 2019, Charlie estimated that the waiting line for Indian applicants would be approximately
8.4 years.
8.4 years. Now, I hate the fact that it was 8.4 years, because one thing I can promise you is it's not 8.4 years. It could be 8.3 years, it could be 8.6, it could be 9, it could be 7, it could be 6, or if we have statutory changes, it could be 2. Nobody knows how long the waiting line is going to be. This is Charlie's, Mr. Oppenheimer, Director of Immigrant Visa Control for the State Department for the past 25 years or so. Basically, what Mr. Oppenheimer is telling you is that this is some information that you can use based on current filings, based on current. I've spoken extensively about the 4 Ds: death, dropout, denial, divorce. so many things that can affect
Age outs.
Obviously, there's less people in the line. But for me, for an Indian applicant, if Charlie is saying 8.4, we've got to listen to that. The only protection you get under the Child Status Protection Act is the time the petition was pending. So
with USCIS.
With USCIS, thank you for clarifying. So that could be 12 months, or it could be 24 months, or it could be 36 months. But what we will do in this office is take an average and say 2 years. Charlie says 8 years is the waiting line, so you can technically subtract 2 years from the 8.6 and end up with a 6.5. My math is not on, which is why I'm a lawyer and not a scientist, but approximately 6 years, 7 years. So, Joe, how low would we go on an Indian applicant in order to be safe? Are we safe at 15? 15 and 7 is 22. So we're not 100% safe at 15. Are we safe at 14? I'm not giving you any guarantees, but I think a 14-year-old is good for me. A 15-year-old needs to know that there's some element of risk. A 16-year-old is probably going to get hit on the head if we don't have changes. So there's the answer to your question. One more time, this is not legal advice. This is pure speculation. As I said, almost all of this information comes from my little black ball and not from reliable sources. But you decide. Why 520Z processing time increased from 20 to 45 months? It didn't. Processing times did not increase from 20 to 45 months. One is we have seen a slowdown in processing. And I think the reason we've seen a slowdown in processing, my personal view, is that they may want to hit us over the head with these new regs, and they may want to hit us over the head with their new statute, but I have no idea why. Virtually no one has been getting many adjudications, approvals, or otherwise since about March of this year. We still get a little trickle, but we used to get a flood. Almost every Monday was joy with all the approvals and RFEs. Now, we're just not seeing a lot of. So in terms of the 40
leadership too, right, at IPO potentially.
Well, we don't know. Julia Harrison was acting director. Now Sarah Kendall is in charge. I cannot say whether the change in leadership is responsible for this. What I do know is it happened more or less at the same time. Sarah came in. Unfortunately, Julia was transferred out. I think she did a really good job, or she tried really hard. But I'm hopeful that Sarah will follow in her footsteps. So let's answer this question. 20 to 45 months is not accurate. And plus, I don't think it's 20. I think it's 24 or something. 25. It's 25 to 45. 45 is so that it makes it more difficult for you to file a mandamus. But Joe's still filing mandamus because it's you can argue that it's unreasonable period of time. 45 months is, quite frankly, not unreasonable. It's ridiculous. But they are saying that that's only a small percentage. This is to stop you from bothering them every week with inquiries, because they can now say, sorry, you're within current processing times. 45 months, really? 4 years? I mean, are you serious? This is insane. Pay $3,650, wait 4 years. Oh, and by the way, there's going to be a fee increase soon. There's talk about they want to charge even more. Hopefully, they will start adjudicating for those ridiculous fees. So it's only a small percentage of cases that are going to take 4 years. They said in one of the publications, it said 9%, only less than 10% are actually at that extreme, but they're using that to stop you. When is the publication date? Publication date of the regs? We don't know, Diane. We don't know when the publication is, but we're expecting it within a week or two, and certainly before September 30th. The whole idea, again, is to use these regs as the incentive to move forward on the regs. I love these questions. It's actually making it easier to answer. I filed my 526 a couple months ago that was not approved. Will the new minimum affect my application? So Joe kind of addressed that. Homeland Security has long had the view, and the government has the view, that retroactive laws are not constitutional, not due process. They don't like making things retroactive, and there will certainly be litigation if they attempt to do that. So the general consensus is that these changes will be prospective. If they change the TEA right now, and all these regional centers and petitions that relied on them would certainly run into problems. So we are anticipating, but nobody knows the answer to that.
Well, but to be clear, there could be an impact, not on pending cases, but on the future cases. Let's say a project no longer qualifies under the minimum investment amount. They're no longer in a TEA under these new rules. Well, then it would be more difficult for the EB-5 issuer to find investors to invest that higher amount. And so there could be some, I don't want to say it's an impact on your case, but an impact on the project in which you are investing. It might make it more difficult to find investors to complete the EB-5 raise.
That is 100% exactly correct. I just need to get one more. So any current argument in favor of a lower 700, the lower amounts are going to come from Congress, hopefully when we extend. So let's keep going through these questions because they're actually right on topic. Will the TA looking shucks.
Yeah, it keeps rolling.
It's froze.
Really?
I think, sorry, we have a little technical snafu here.
You must be getting so many questions.
I don't know exactly what that is. So let me flip over to another critical point that we're going to discuss today. Don't worry about it. Forget about it. So let me talk about. It doesn't matter. Okay. Let's move the slide. Is it frozen?
Seems like it's.
Okay. The PowerPoint's irrelevant. Let's focus on addressing the issues that are currently challenging and important. One of the other critical elements that was in the NPRM is priority date retention. The provision allows for some level, thank you,
Those are the next couple.
of priority date retention, but it's quite narrow. It does not protect investors where there is material change such as fraud. It basically, if the regional center goes out of business, you can hold the priority date for a second filing. That is my understanding of what NPR does. It is woefully inadequate in the proposal. Ayla made a recommendation that we should permit priority date retention in situations where the foreign national was defrauded, in situations where there's force majeure or other such conditions that make it impossible to, in fact, complete it. We in AILA want or hope that we would be able to get changes such that it would clearly cover material changes regardless of the petitioner's status. We also would love to see a priority date retention which allows them to substitute, or a petitioner to substitute, the child for the principal. So those, we understand, may not be in the current proposal, so that presents somewhat of a challenge. There is, unfortunately, neither in the regs or even in the proposed bill a provision to address backlog issue and a visa capacity issue. So that's somewhat of a problem. Sorry, our slides seem to have somewhat frozen, but that doesn't stop us in any sense from moving forward.
Well, the next slide would have been about the September 30th, 2019 sunset for the Regional Center program. This, as you may know, it's a short-term program that needs Congress to extend it for it to remain in existence. It's been extended some 15 times or so since 2012. And as Bernie mentioned before, we anticipate it will be extended again, but likely with some reforms. I know we've said that in the past, but it does appear that this time is a bit different based on the fact that, here we go, it looks like we're back up. Just one more. Based on the fact that we are, thank you, we're seeing these regs being finalized. So that's the big difference here.
So what I wanted to do is to briefly summarize what is in the skinny bill. So on May the 17th, 2019, the industry submitted a reform and reauthorization suggestion. There was a sign-on by pretty much everybody, IIUSA, AILA, all the U.S. Chamber of Commerce, everybody, the entire industry has combined. And the recommendation is that project in a TA should go up to 800 and 900 if it is not a TEA. So you notice the delta here is very narrow, only 100,000. The industry wants to effectively make the delta between TA and non-TA very narrow. We don't know if, in fact, that's what's going to end up. That's not what's in the proposed regs, but that would make sense. The suggestion, of course, is to try and get a 6-year extension, extensive integrity measures to bolster the national security and fraud deterrence. That obviously is something the industry supported. A more limited view of TEA definition. The urban distressed area definition is revised. I'm not going to go into the nitty gritty, but they also are talking about in designating and including qualified opportunity zones as defined by the Treasury Department. So that is some of the key provisions. The other thing about the September 30th bill, which I do think is fairly realistic, is the possibility of TEA set-asides, the old 15% for rural, 15% for urban distressed. We do expect the possibility of seeing TEA set-asides in the proposed regulations, in the proposed statute.
The thought being with those set-asides is that if you invest in a project that's in a TEA or rural area or other sort of manufacturing or whatever the case may be, whatever the criteria is that a certain number of visas would be set aside from the annual allocation to give those an incentive to invest in those areas, because you would be able to get your conditional green card status a little bit quicker.
A lot quicker, quite frankly, because if you're a Chinese national stuck in the waiting line, but of course for those people who are already in the waiting line, it makes it so much worse. So set-asides are somewhat unfair to the people who've already invested and put their money in, but it does keep the industry alive.
Yeah. Well, I think this kind of ties into 1044, right? I mean, changes in how the visas are processed.
So, all right, let's get into 1044. 1044, you know, at the heart of 1044, that is, so basically the way it works is you have 140,000 employment visas. 7.1% of that goes to EB-5. That's 9,940 visas. And then each country gets 7% of 9,940, which is 695.5 or 696 visas. So every country right now, and let's just forget about China, because China has all the low visa numbers, people stuck from the May 2015 retrogression. And at the end of the day, because there are so many Chinese cases ahead, every other country will only get approximately 700 visas. India, Vietnam, I guess, are the two that have already been hit with retrogression. Vietnam was hit in May 2018. India was hit for the first time this month with retrogression, with the backlog. And the number of Indian families, the Indian multiplier is relatively low because a lot of single people. So you probably have about maximum 250 families or individuals from India able to immigrate annually. And with Vietnamese, maybe about 225 families per year under the current law. So everybody else, to my knowledge, there is no third country about to hit this quota and to have retrogression, but we never know. So right now we have 3 countries facing retrogression, 3 countries that have this particular problem with regard to visa backlogs and visa cutoff dates. So moving forward on this issue.
Well, actually, the August 2019 visa bulletin was just released this morning. And it all tracks China now. So this is what it was in July of 2019. If you are an EB-5 investor, you are only able to move forward with the next step of your EB-5 process if your I-526 is approved, if your priority date is before May 1st, 2017. Starting in August, that will track China. So it'll be, unless your case was filed before October 1st, 2014. The same with Vietnam.
So this is really important to understand. When Mr. Oppenheim puts Vietnam, do we have a sound issue?
Yes.
The sound is not working?
It's kind of too low.
We can talk louder.
Sorry, guys. We're having a lot of technical issues today. Are we back up with sound?
Turn the gain to the maximum.
All right. Hopefully you can all hear me. If not, somebody send me an email. Bernie, you're too loud. So what Mr. Oppenheimer is doing here by bringing everybody, meaning India and Vietnam, to the China date is he's effectively closing the door because there are no Indians or Chinese with the China date. Did he keep the China date at October 1?
Yeah.
Okay.
Yeah.
So basically, he has frozen India and he has frozen Vietnam for the end of the year. So they're probably going to send out some notices that are going to cause some panic. There might already be some interviews. What's more important and most important is not what Charlie is doing now, but what in fact is going to happen in October 2019, which is the beginning of the 2020 immigration fiscal year. So I'm going to look at my notes to make sure that I have this correct. The India final action date will advance to summer or fall of 2017. So summer is that June, fall, September, but it's probably going to be somewhere between June and September 2017. That means all the 2018 cases are stuck, but it certainly means that anybody from India with, for example, an April or May 2017 date, you have no problem. If you're from India and your priority date is April, May, June, July, you're probably going to be okay. And then it's going to start moving. We don't know how fast it's going to move. So the analysis for Vietnam, which is equally important. Again, Vietnam effectively closed for the month of August because they moved it to the China date. So Vietnam in October will open somewhere between fall, that is September, and winter, what is that? January, February? No, winter 2016 has to be December, right? So it's because it's still 16. So it's probably sometime between September and December 2016. So basically, all Vietnamese with 2016 priority dates, you're going to be okay, in my opinion. The 2017 Vietnamese are going to be stuck. 2018 are going to be stuck, and it's going to move quite slowly. So some of this might be quite complicated.
That being because there's only 700 visas that are given out each year.
Or about 225 families per year. And that being because there are so many Chinese nationals with much lower priority dates because they got hit with retrogression 3 years before Vietnam. So all those people during that 3-year period are effectively ahead of everybody. All right, so Joe, you wanted to talk about 1044. So there's a whole lot of excitement going on today because the House passed House Bill 1044, 365 to 60. And the Senate bill, which is similar but significant differences, is also well, there's a bill that doesn't have the kind of support that the House bill has. Now, I want to start off by saying that there are currently at least 2 holds on this bill. I believe Rand Paul put a hold. Someone else put a hold trying to get nurse the impact of this. So if HR 1044 passes, basically what it will do, one prediction, Stuart Anderson, probably most reliable, has done an analysis which says all EB2 and 3 would be 6 to 7 years if, in fact, this bill goes through. So obviously, if you're from India, China, or other retrogressed country, you will want to support HR 1044. And if you're not from one of these countries, you may be less enthusiastic. I find this horrible. I think basically it's sort of pitting one group against the other. It's like we all little dogs scratching for scraps that are being thrown out. What we really need is comprehensive immigration reform. These limits were set in 1990, 29 years ago. Our economy has grown 5 times since that time, and the visa numbers have remained the same, pitting one group against the other. So here's how this would work for EB-5. What 1044 would do is it takes the top 2 countries, China and Vietnam. I've got to just go slowly on this. They are handicapped to some degree, but they will probably get most of the visas. So it will clear the backlog for China and Vietnam. But there is a 15% reserve in year 1, a 10% reserve in year 2, and a 10% reserve in year 3 for what I'm going to call rest of the world. That is other than China and Vietnam, the 2 most largest consumers of EB-5. Now, Zoe Lofgren, who was an AILA member, by the way, very powerful Democrat, had put in a provision, which is what we call a no harm provision for people with approved petitions. So at the end of the day, I don't know, and I don't think anybody fully understands what that means, but it basically means that if you do have an approved petition, you cannot be harmed by this removal of the 7% per country limitation. I don't think anybody's done the math.
Yeah, I'm not sure how that's going to be working.
Of how that would work. But I'm not going to get excited over 1044 because I don't believe 1044 is going to go through. There's a lot of buzz about it. Talk is the White House doesn't support it. The reason the White House doesn't support it is that they have a different view of how immigration should be reformed. So, there just isn't enough support. I don't think this bill is going to go through as we currently see it. So,
I just want
Joe,
to keep moving because
of
we have 15
time.
Minutes. Yeah, we have 15
Joe,
minutes here.
take it away. Redeployment. And before we get into redeployment, let me just tell you what my problem is here. So there are people from China. So basically the rule, of course, is that the investment has to be sustained up until the time of filing of the 829. The jobs have to be created within a reasonable time, but the investment, the cash, has to be sustained all the way through to the filing of the 829. So for people from China who may have a 15-year waiting line, do they, in fact, have to have their money tied up for 20 years? And what about the project documents that said the loan has to be repaid in 5 or 6 years? And the question is, can the project redeploy? Joe, take it away on this issue because it's a burning issue for those folks stuck in redeployment, and the guidelines that we've received from the government are not 100% clear.
Sure. So in June of 2017, USCIS put out a new policy guidance out of the blue. Very vague definitions. You must invest within the scope of the new commercial enterprise. It must be done within a commercially reasonable amount of time. A lot of room for interpretation. The key is making sure, in my opinion, the key is making sure that there is funds that are liquid, and also making sure that there is enough protection on those investments. And the reason why is every investor, no matter what project you're in, you're going to have a different time in which you're able to get your money back. The regulations only require that your money be sustained for your 2 years of conditional green card status. Well, the beginning of your conditional green card status depends on what country you're from and when you filed your case. And so what we're seeing now are projects that were a little bit older and didn't have this contemplated in it. They're going back to their investors and they're saying, look, maybe we need to amend our operating agreement of the new commercial enterprise to allow us to redeploy this capital. Or we're going to need to amend the operating agreement or the limited partnership agreement to allow us to return the money earlier. Because before this policy guidance came out, the conservative point of view was that your money needed to be sustained until the I-829 got approved, despite the fact that that's not what the regulations said. Now the regulations say, okay, only the 2 years. So to give investors that ability to get their money back earlier, there may need to be some changes in the operating agreement. How this is being done depends on the project and the issuer and the regional center. And so we're seeing a lot of cases right now. You may read about lawsuits, litigation out there about maybe you're not disclosing what you're doing with the redeployment. Are you giving them the ability to look at the different options and choose? Do you have an independent evaluator looking at the different investment options? You know, those are different things that these issuers, the new commercial enterprises, the companies in which the investors are owners of, operate. And so I think there's a lot of timing issues and practical issues involved with this, in the sense that those who have your conditional green card, they may be more inclined to allow for a redeployment as opposed to those who haven't gotten it yet, who are stuck in that backlog. And the reason why is, well, is this a material change? I think USCIS would say that these aren't material changes. I think that they have sort of written that into the regs, the policy guidance, a fair amount. You know, as long as people are taking the good faith effort to try to comply, I think that will be, I don't want to say sufficient, but I think it certainly helps an investor's case.
So Joe, we have a good question here. Will the pending or to be filed IA-29 be affected by the sunset of the RC program? And the answer, firstly, the program's not going to sunset. But if hypothetically, whatever, it started raining money or something, and they sunset the program, my answer to that is absolutely not. I do not see any possibility that 829s are at risk in the extremely remote chance that 829 is not approved.
Or even those who have approved I-526s and don't have pending 829s at this time. I think you would be grandfathered in under the current rules.
So there's talk about what would the impact of having an exemplar on a particular project, how would it be affected by the new regs? That's coming from Diane as well. My feeling is that, again, the possibility of having retroactive application in regard to previously approved projects which we've relied on would open up a beautiful lawsuit that could well be successful. Look, the government is allowed to make changes. The government is allowed to change the program, but I think if people are so adversely impacted and they relied on it and they're in the process, we are expecting this to be prospective moving ahead. So, Joe, I think you agree with that as well?
Yeah, I do. Did you want to talk about this? This kind of a interesting aspect here, because of redeployment and because of the backlog. Excuse me, because of the backlogs.
Death?
Yeah, the death.
You want to talk about death?
Oh.
Can we just talk about life?
Okay.
It's so much more fun. Joe just has a new little baby, so he's more into life than death. Little Jack, he's very, very cute. So, yeah. Look, if it's a 15-year waiting line, and I'm really just bragging right now because we think we got our first 204L approval. I have had 204L approvals in other than EB-5, but if it's a 15-year waiting line, is there a chance that some of these principal applicants will die? And the answer is yes. Death does come naturally to old people, sadly. And the bottom line is that a petition is automatically revoked. Employment-based petition is automatically revoked upon death of the principal. So one of the rules I've had for years is that the female spouse should always be the principal applicant. No, it's not an at Me Too moment. That's not the reason I'm suggesting that the female have the money and be the principal applicant. It's just statistically women live longer than guys. So, you do need to look at the health of the principal applicant, because if the principal dies and the spouse and children lose eligibility unless that they can argue that they were resident in the United States at the time of death. Now, resident in the United States does not mean that you had a green card, because obviously it doesn't mean you have a green card because you're applying for a green card. But so, for example, if normally what's going to happen is that the child is in the United States on an F1 study. In my particular case, the kid was here for high school, has been here for years and years, and I just got an email back from the IPO saying your petition has not been revoked. So since the law says it is automatically revoked, but the actual adjudication will come in the process of an adjustment interview. We haven't done it in consular processing yet. I do believe we could consular process the case, but if the argument is the person is resident, USCIS presumably expects the case to be filed as an adjustment if they are eligible. So we haven't filed that adjustment yet. We expect to do it. We'll argue in front of the officer, but the IPO has agreed with my brief and not automatically revoked. So we're all celebrating that the law, this is called the widow provision, or should it be called the widower provision? But it's the old widow provision that allows for preservation of the I-130 if a nuclear family member, such as a kid, has been resident in the United States, for example, on a student visa. So that's good news. Have we got all the questions, Joe?
Yeah, it looks like there's a couple more that trickle in. I think we can answer in the last 5 minutes or so.
Good.
What about August 2019 visa bulletin?
We discussed that.
Talked about that.
This is a question for you, Joey.
Can investors ask their regional center not to redeploy their money and hand it back to the investor, even though the limited partnership may not have language to support it? Well, the answer to that is no, you can't, for a couple reasons. Number one, if the money goes back to the investor...
Wait. They can ask for it. The question is, what would happen?
Okay, so yes, sure, you can ask. You can always ask. There's no problem with asking.
But the answer is probably going to be no.
The answer will be no for two reasons. Number one, if you get your money back from the NCE, you're no longer sustained, and unless you've passed that 2-year green card status, you're going to get your 829 denied. The second thing is, as an NCE, as a limited partnership or an LLC, you must treat all members equally. So if you give one investor's money back, well, other investors will have a claim against the NCE for saying you didn't treat us equally and fairly. Why would you give him money back and not me?
Actually, they're clarifying the question, which is they want to withdraw the application. So if they withdraw the application, refund of the money is going to depend on the subscription agreement and the terms of the documents. But generally speaking, most regional centers will not refund the money on the principle that if I refund the money to you, it is not irrevocably committed for all the others, because basically anybody can get their money back at any time. That would mitigate against whether the investment is truly sustained and put at risk. So getting the money back is quite difficult for people who want to withdraw. Another really good question, Diane, your questions are great. We spoke about the possibility that a 16-year-old Indian national could age out. We spoke, although I didn't speak about it, the possibility that a 15-year-old, scratch that, a 15-year-old Vietnamese is probably safe, in my opinion, because the waiting line for Vietnam is slightly less. But nevertheless, the question here is what to do. We have filed and got approvals for 15-year-olds. So my advice is file with the child as the principal applicant. And the other question you have is, can you file, so somebody who's not backlogged, what if the principal is not in good health or, elderly parents? The bottom line is there's no age restriction on filing an EB-5. The only issue that is coming into play, even in EB-5, is public charge. So if you bring in an 85-year-old principal, you need to show that there's going to be adequate medical insurance. This person will not be a burden, but presumably if you're doing a $500,000 investment, you have some money, and just set up an appropriate trust, as it were, or otherwise prove to the government that, in fact, this person will not become a burden on the state, such that they can be denied under 212A4 for public charge. So I think we have covered pretty much all of the questions for today. I wanted to keep it at an hour. We haven't been doing too many of these webinars lately, but I thought I would share some of this new cutting edge news. That's what Joey looks like, handsome guy he is. That's the old man. That's the when you were young, Joe. And that's me when I was young too. Guys, if you have questions, ladies and gentlemen, visalaw@wolfsdorf.com, or even better still, if you want an intelligent answer, go to jbarnett@wolfsdorf.com. If you've got positive comments, share them with us. If you've got negative comments, send them to Joe. No, we want to hear either way about how we can improve. Sorry, this was a little bit ad hoc. I just got this idea 2 or 3 days ago to share some of this information with you. I hope it's been helpful. And thank you so much, everybody, for joining us today. And how do we find the end button? And that's a special thanks to Eddie, our technology guru.